have in Niesv. And I'm happy that your chairman and his ESCO is doing well. Let me also say that we have met with the Copyright Commission, and the essence is that we want to collaborate with them on the issue of violation of intellectual properties and business assets. Most times we concentrate on the tangible assets owned by the company or whoever that is carrying out valuation. But we forget those intangible things that actually bring out the business potential of the organization. So having realized that as valuers, we have a role to play in the valuation of intellectual properties, I think that we need to train and be retrained. And you cannot be able to do that unless we have professionals who are competent in this area and who have experience in this part of our profession to be able to also teach others on the way to go on this aspect of our job. So on behalf of the National Council, I want to congratulate the professional group for finding time to learn, for finding time to come for the training. And let me also say that it is high time we leave the idea of jack of all trades and master of all. It's no longer working anywhere in the world. You must identify your area of competence. You must know where your passion is and follow it so that the people working for will be able to know that that is the area you are competent on. If we don't do that, we'll still be complaining that people are taking our jobs. There must be a difference between an estate surveyor and valuer and a non-estate surveyor and valuer in whatever services that we have rendered to our service users. And the only way to distinguish ourselves is to do it professionally, following the ethics, the professional ethics of our profession. Lastly, let me also say that the institution, through the council, will be willing to support these groups and ensure that we encourage our members to belong to at least 2 professional groups or maximum of 4 professional groups. The essence is that we want to encourage our members to go into specialization so that we all be competent in whatever thing we are doing. I hereby declare this webinar open. Thank you very much, and God bless you all. And I wish you a successful training and a successful deliberation.
Thank you, my president. Thank you very much, sir. We really appreciate your time because I know that you have another meeting. Thank you very much for coming, and we promise that we will not let you down at the end of the day. Thank you very much, sir. So quickly, we have to move into the, yes, sir.
You will allow me out so that you can continue with your seminar. But I will plead that you also send me the recorded version so that it will be in our library. So I will need a copy at the end of the thing and also a report from you on what we have done so that we can present it during our next council meeting. Thank you very much.
Okay. Thank you very much, sir. You're welcome, sir. Please, technical, check our audio. One of the resource person cannot even hear what we are saying. Please. Mr. Umar.
Yeah, I think I can hear you.
You can hear us now. Okay, thank you very much.
Let him log out from one device. Let him log out from one device. I can hear you.
Okay, thank you very much. Well, without wasting time, we need to proceed into what we are really here for. And the person that is going to take the lead is Barrister Nusa Uwademe. Barrister Nusa is the managing partner of G Law Firm in Lagos. He's an intellectual property specialist, advertising law, press law, media law, entertainment law, then consultant. So it's somebody that has passion for IP. In one of our discussion, he mentioned, he said, look, we have already talked about the protection. What of the economic side of it? Then we need to talk about it. So is the convener of the premier IP workshop on advertising and media in Nigeria, and is also the originator of IP radio in Nigeria. He's the founder of IP radio in Nigeria, and we have held a series of seminars on that. And he's also has a certificate in media enterprise, School of Media and Communication, Pan-African University, Lagos. So it's somebody that really knows the terrain, and that is why we want him to come on board to share his experience with us about what he knows about the IP. And that is why we are looking at it that IP, the law and the valuation, they are related. So he's going to demonstrate to us how they are related, and at the end of the day, I'm sure all of us will really benefit from it. I would like to welcome Mr. Nusa on board. You are welcome, sir.
Thank you so much, sir. Can we hear me, sir?
Yes, I can hear you.
Okay, so I want to thank the NIESV for the privilege of bringing me in to speak about intellectual property as it relates to IP law, IP valuation, and commercialization. I'll just go straight into it with a preamble. Please, I would appreciate if my slides can be shared, though I'll be using my own to speak through it too. How many minutes do I have, sir?
You have 25, sir.
Okay, so I'll just go straight into it. Every enterprise, the essence of doing any business is, one, to ensure that the business is sustainable and to make money from it. At least give returns on investment to those who have reposed enough confidence in us to be able to join us to set up business. So every business enterprise normally would have three major components: the monetary side, the tangible, and the intangible. The monetary side is cash flow, cash at hand, and whatever you have in the bank that you can just liquid. The tangible one is the brick and mortar, the furniture, the factories, everything that eyes can see. The intangible one is the intellectual property assets, which are not very visible to the common eye, but constitute a very cogent part for the sustainability of that business. And this has grown over the years. This has grown over the years from insignificant to something very significant now. And you will see as we proceed. So what do we really see? In the developing countries, you discover that intellectual property has not been given recognition that it's supposed to have, because our economies are still growing and a lot of forces that are extraneous to business itself seem to dominate the landscape. Even within the terrain of estate surveyors and valuers, it's just beginning to gain ground. And that is why I'm very excited that the estate surveyors and valuers are beginning to also consider it very necessary to look at intellectual property as part and parcel of their business. Our concentration has always been in the brick and mortar. We've forgotten intellectual property assets like goodwill, copyright, patents, trademarks, and trade secrets. So what basically is law? Like the moderator said, let's begin to tie it in gradually. Law is more or less like a body of rules that the society or government develops. So it's not sacrosanct, it's not a destination per se, it's an evolving process as the society comes to embrace new dynamics So it's a body of rules to deal with crime, business agreements, and social relationships. In this case, we are more concerned with the business agreements. So what is intellectual property law? Intellectual property law actually focuses on the intangibles. It focuses on the creation of the mind, the creation of the intellect. And what the creations like inventions, designs, brands, artwork, music, anything that emanates from the human intellect that is not physically on the ground from the immediate. However, through various processes, what has become intangible will eventually become tangible. So what intellectual property does is properly establish that intangible, to give it a form and a shape, and to also ensure that it is protected. So the law actually gives the owner of the intellectual property, that means the person that created the intellectual property, whether it's its logo, whether it's a brand, whatever it is, it gives him some level of monopoly to enjoy the exclusive use of that which he has created for a period of time before it falls into what we call in law the public domain. So what intellectual property does basically is to create a balance between creativity, reward for creativity, monetary reward, financial reward, as well as for the public to also enjoy it. So when people say intellectual property is a negative right, I argue with them. It is not a negative right. It just gives the owner exclusivity for some time to reap where he had sown, after which the public can now use it for whatever they want to do. I'm speaking through the site, but you can just go through. I'm sure the slides will be given at the end of the day. So what are the type of intellectual property that we have? We have copyright. Copyright is the most popular because and it basically protects literary works, musical works, artistic works, cinematography, sound recording, and broadcast. It's an exclusive right given by statute to ensure that whoever has the right, the author, that is the originator, has exclusive rights to control the doing of some work, of his work, and prohibit other people from doing such, mainly in terms of reproducing, adaptation, and so many other ways people want to deal with it. If you produce, for example, a novel now, somebody can just wake up and go to the streets and begin to shoot your movie. And copyright law says, no, you don't have the right to do that. Before you can do anything with what that man has created, you need to get back to him, seek his consent, either he assigns it, he licenses it, and pay him money for doing it. So you can't just pick something from a novel and go and start to shoot film in it. And so that's what it does. It prohibits unauthorized use. So for copyright, interestingly, to come into fruition or for it to become active, for whatever work you do, it doesn't need to be registered to enjoy protection. However, we always advise as lawyers that it is proper that you register your copyright with the Copyright Commission, essentially because it gives room for you to have a record, that a global record, especially for you to enjoy conventions that Nigerians have signed to globally, you know, the Berne Convention and the other convention. In about 177 countries or so, your work will be recognized just simply because you have registered. And it also acts as a prima facie evidence when it comes to litigation that at least you are the one that owns it. There are so many other benefits, but so we lawyers always advertise that even though copyright emanates from the time you create and you are the owner, we advise that you register it. So, like I said, it doesn't go perpetually. So for literary works, it lasts for 70 years after the death of the author of the novel, of the literary work, of the artistic work, of the musical work. While copyright in films lasts 50 years after the year the work was first published. Ditto for sound recording. So what are the copyright that are in the real estate covers? If you are an estate valuer or you are into estate surveying, what it basically covers are building plans, photographs, virtual tours, artistic renderings, floor plans, creative descriptions, and architectural drawings. So if you have any of this, copyright comes on it immediately, but I will advise that you recognize it. Trademarks basically is one that talks about the source, the origin of any product or any service. It could be a logo, it could be a domain name, it could be a sound, whatever it is that has been identified with your business in the marketplace, that once anybody does anything close to it, it's likely to cause confusion and it is likely to be deceptive. So trademark laws protect you from anybody usurping that particular recognition that you have. So it provides exclusive right for you to use those products that have been identified with you, that have been identified with your brand. So what trademark does basically is that it rewards initiatives and it ensures that you attain sufficient recognition for you to make profit. It also enables people to develop skills. To register your trademark, it's important that you register your trademark for you to be able to have protection and for you to avail yourself of the benefits when it's being infringed. For you to have the power to go to court or to fight for your protection of your goods, it's important that you register it. And that can be done in the Commercial Law Department, Ministry of Trade, Ministry of Trade and Investment. Trademarks are, like I said, it's important you register to enforce your rights. However, if it's not registered also, an action in passing off also avails you of that opportunity to still ensure that you can protect your trademarks. Trademarks are registered for an initial period of 7 years, but you can renew for subsequent 14 years. Examples of notable registered trademarks are real estate at Trump Tower. These are all in the United States. Empire State Building, Sears Tower. I'm sure Niesv Akim will be able to tell us the ones that have been registered in Nigeria, if they have been registered at all. Can you hear me?
I can hear you, sir. I can hear you.
Okay, I just want to be sure that people are hearing me.
Yes,
I'm wondering why we are using Trump Tower and CS Towers when we should be using Andron Homes and Revolution Plus. Okay, let me move on. So patents are basically for new inventions. It must have an inventive step. It must definitely be an improvement on what we have on ground. And it gives the owner the right to prevent others from making use of your patents. For example, if you have patented a product or a process, mainly a process-based invention, because patents more deal with processes and of invention and the newness of invention. You can stop anybody from importing it, using it, selling it without your permission. Like I said, it must be an inventive step. It must be capable of industrial application, which means that it should be replicated and it should be industry specific. It can't be vague. It has to be, this is the solution for this particular industry, and it must be such that it can be replicated. Obviously, they won't grant you a patent if it cannot be replicated. And it must not be against public policy or morality. So they can't give you a patent for anything that promotes immorality or irregular behavior. So the patent is governed by the Patent and Design Act, and it endures for 20 years from the date of filing relevant application. Registration is mandatory for enforcement. Industrial design basically covers the look and feel. It covers what people see with their eyes. It covers how it is shaped, how your products are shaped, and what the ordinary man in the street can see. So basically the lines, the contours, the patterns. And it must also be registered. It must also be registered. And the certificate must be issued to you. The duration is for 5 years with the possibility of renewal of up to 15 years. The interesting thing about the industrial design is that you can license it, you can also authorize other people to use it. as we progress, you will see why it is important that these intellectual property rights are such that they don't remain with one person. They are movable. We actually say that they are also movable assets. The only thing is that you are not carrying a table or chair, but you are carrying the products of people's intellect. So it has the same property as a real property, as a real estate. Whatever you can do with a real estate, you can also do with intellectual property. And that ties in with the subject matter of today, that there is a nexus between real property and intellectual property. So trade secrets are basically those information that gives you a competitive edge in the marketplace. So you have some sensitive information, your client list, your marketing strategies, every other thing that goes with it. How do you ensure that your employers don't give out these things? How do you ensure that your competitors don't get all this information? Because these trade secrets are what actually make you who you are and differentiates you from other companies, because your competitive edge. So you have to take reasonable steps to protect it. And that's what intellectual property does. Unfortunately, the moment it's no longer a secret, trade secrets become nullified as an intellectual property right. So what is valuation? I won't spend too much time on this because that is my brother's forte. But just say that it is a process of determining the present state value of an asset. There's a principle, okay, and IP valuation is basically the same thing. The only thing is that what you are determining at this point is not just valuation as a broad sense, but you are determining the actual value of the intellectual property assets in any service, in any company, in any organization, be it patent, trademarks, copyright, and trade secret. There are several prerequisites for IP valuation, but suffice it to say that it must be clearly identifiable. You can't mix the value with other assets in the company. It must be capable of being sold or projected on its own. And it must not affect, at the end of the day, by the time you deal with it, it should have nothing to do with every other asset. So it's like I told you, it's like you have 4 buildings as a company. If you want to sell one, you can sell one independent of the rest. So for valuation to be able to come upon any of those assets, any of your intellectual assets must also be like a real asset. And it should be transferable, it should be enforceable as your own. Clearly distinct, having his own life, having his own trading opportunities. So why do you need to value? There's a principle in law that says nemo dat quod non habet, which means that you cannot give what you don't have. So if you want to sell, we are moving towards the commercialization now. So if you want to sell, you are out maybe for a joint venture or something like that, and you want to partner or you want to do anything. They say, what are you bringing to the table? Apart from bringing your factories, you also bring your intangibles, which are your intellectual property. But before you can sell, you must value. The same way you value a property, before you can sell, you must also place a value on the intangible assets that you have. And in Nigeria, it's becoming more interesting because you can actually use your IP valuation in terms of the commercial monetary benefits or financial benefit to secure loans, to attract investment, to settle disputes. When you're having disputes with another company and any other thing, and it comes to maybe some kind of financial exchange, you can say, look, I don't just have this building, but I also have intangible assets. Can we monetize it? So it's very important for franchising. For tax reasons, it's sine qua non, it's second to none. For insurance, it's also becoming very, very, very key now. So what are the methods? The income method, the market method, the cost method. Essentially, we've gone through the basics, but just to say that one of the objectives is to determine your interest in that asset. For example, there are some assets like real property estates that have 3 or 4 people that own those assets. So if one person is going to sell that asset, what part of that property is his own? The same thing we have with IP. 3 of us can own the IP of something. For example, if we did the film jointly and we own it, we have a joint ownership. To be able to deal with that intellectual property, to be able to sell it, you need to be able to determine exactly what is my own portion. The same thing with real estate. Now, so many conglomerates come together to form and do a project. So you now want to sell your own. We need to be able to determine what is your own portion in that real estate. And this would have to do with a lot of metrics, including the remaining lifespan of that intellectual property. So we've given you various years by which intellectual property rights are enjoyed. At the time you are selling, at the time you are dealing with it, what is the remaining lifespan and what is the financial figure to be attached to that? So I'm just going to briefly run through the valuation because it takes a lot of mathematics to do this. But just to say that the income method is such that it looks at, like I've said, what is the economic value of the IP that you have, especially with regards to the future. So this one looks at it, that what is it likely to generate in the future. In that way, they are able to work out the value. Okay. Okay, next 10 years, because the intellectual property has already been used for like 10 years. For the next 10 years, what will be the future value? How much is it going to be able to generate in terms of income in the future? And they use that as a basis of doing the valuation. But that presupposes that your business is very definite, the cash flow moves up. I mean, it's very steady, so it's predictable. So this is just one of the methods. The market method, which I think is the most popular, is the one that actually just looks at, okay, if I'm going to sell my intellectual property in XYZ company, what is exactly the price of buying that same thing outside? How much does it cost? So you compare similar assets, onion for onion, orange for orange. So how much would I eventually, the similar type of assets that one is, how much will be paid for it? So you just directly compare and see how the market flows. So knowledge about the market, what is happening in the market, determines that a lot. Then the last one is that you also look at the similar assets. If you are going to reproduce, for example, if I'm going to reproduce exactly this asset that I have, exactly, how much did it cost me to do it? How much would I need to spend? So you just look at it from that point of view, that you look at it from the cost point of view. However, the fallacy in this is that you don't look at so many wasted costs, you don't look at market forces, you don't look at every other thing, you just deal in isolation and say, this thing cost me 10 naira to get to this point, from registration to development to R&D. So this should be the cost. It's not a very popular one, but it's also workable. So let's just move to, so I said, my own view is that intellectual property law and IP valuation are complementary tools to actualize IP commercialization. Commercialization basically is just to transform an idea into an established form that people can buy. So whatever you have, what is the process of putting it together so that people can see it as something they can buy? Like I told you, you have to transform the intangible to the tangible. And that process is basically what we call commercialization. So I'll just run through some few within the remaining time I have. One of the key areas you look at is licensing. Licensing basically means that a company has some rights. He has an intellectual property. However, he also wants other people to use it for a fee. So he allows, Mr. A has an intellectual property and wants Mr. B to use it. So he passes part of the rights that he has to Mr. B for a limited time, for certain periods, and for a very restricted geographical area for a license fee. Most times it has to do with royalties, at times it also has to do with a lump fee, but most times it has to do Even if there's a long fee, there's also royalties. But it's just for example, you can give somebody a license to operate, let me say for the purpose of this discussion, raise Andron homes, for example. Go and do Andron homes in Ghana, but you are only going to do it in Ghana. Don't do it outside Ghana. And I'm just going to give you for 3 years, and this is how much you are going to pay. So Andron home licenses their trademarks or their intellectual property to Mr. B to use in that. So that is license. It's not a total transfer of rights. It's just a partial transfer. Franchise is another area. So as many of you that have brands, real estate brands that are very successful, you don't have to continue to develop estates. You can actually license some of those estates out and make money if you don't have the resources to continue to build, instead of allowing the assets to waste. Franchising basically has to do with a brand that has a very established name, established system, and just wants to allow other people to use it. The difference is that franchising, the franchisor, who is the one giving the franchise now, still controls a lot of the elements. It controls the marketing, it controls the quality of the service, it controls everything because his trademark is at stake. He has taken years to build that, and he doesn't want that to be tarnished by another person. So the measure of control for franchising is very, very high. But the good thing is that if I'm starting a business today, I don't need to start from the scratch and use Nosa and Co. I can just use Akiwumi and Co, because it's a much more established brand. I can franchise Akiwumi and Co, and the only thing is that he will regulate everything, and I'll pay him a fee, royalty for. So we have an.
Hello? Hello? Hello, Mr. Omore.
I'm with you, sir.
Okay. I think he's trying to come back.
Can you hear me?
Okay, we can hear you now. Welcome back.
Where did I stop, please? Where did I stop? Hello?
You are talking on franchise.
Where did we? Okay, I was talking on franchise. Can you hear
Franchise,
me?
yes. Yes.
Okay, I said that a franchise.
We can hear you, sir.
So I said that a franchise is. I said a franchise basically has to do with somebody who has established a system. There's a sound behind. Can somebody mute that sound? Can we mute every other person apart from
Please
the speaker?
mute every other person, please. Thank you.
So a franchise basically has to do with somebody who already has a system in place. And the person already has a system in place. And with that system, the person is able to control a lot of the things that the other, that whoever he has given the right to is able to control everything about it. And I said that the good thing about franchise is that you don't have to start from the scratch. You can just jump on somebody's shoulder. Like I said, if I want to do estate surveying business now, I don't need to start as Nosa and Co. I will just lean on Akiwumi and Co. and get his franchise. The only thing is that Akinwumi and Co will control my system. He will control my operations. Because he doesn't want me to bastardize his name. But for people who have the resources and the money and want to start big, for example, if I want to start a supermarket, I'll go for a banner. Can you hear me? Can you hear what I'm saying? I'll go for a banner. Can you hear me?
We can hear you.
So, and lean on the shoulder and move faster. So I gave an example of McDonald's. I said McDonald's make more money from their franchise for real estate that they do for their burgers. And they make money from the franchise fee, which the franchisee pays to them for the system and the marketing and everything and the branding to operate a burger shop. And they also make money from the rent, from the property. So if you approach McDonald's, they will tell you that you must use our property for your burger business. And 93% of the McDonald's you see globally is franchise. Out of the 337,855 restaurants they have, 35,000 is franchise, while McDonald's only operates 2,770 restaurants. So they make 93% of their franchise or the McDonald's you see pay rent to McDonald's, and that is why they are more interested in their business of in that business than in the other one. Can we go to the next slide? I'm sure. So essentially, assignment has to do with total transfer of your IP rights. You transfer everything to them, to whoever you are giving it to. But I still advise clients that please don't transfer everything, because that IP can become something very valuable in the future. And you might be thinking that you want to get it back, but if you have fully assigned it, there's no way you can get it back. And assignments must be written, please. If you are assigning anything, which means you are totally transferring your right, please make sure that it is written and it is signed. If it is not written, if it is not signed, it is null and void. It has no purpose. So I looked at 10 real estate brands in Nigeria. From my research, you have the Chagori Group, Jide Taiwo, Adron, Kappa, Dabatu, Cardwell, King's Court, Landmark, Revolution Plus. And so basically, if your rights have been infringed, there are several remedies, both civil and criminal. You can have an injunction for civil action, and a topila, which enables you to go into the premises with police and every other thing and seize the infringing products or whatever is infringing, copyright materials, and take them to the police station and proceed with your enforcement action. You can also be giving damages. Like I said, if you're able to prove yourself in court, you might be awarded damages, you might be awarded account for profit, which means that whoever has been infringing on your copyright, trademarks, whatever, the court will say, how much have you made from it? Please give Mr. X. And like I said earlier, an action of passing off can still lie. In terms of criminal action, too, is also available when somebody infringes your rights. And there are some statutory organizations that the law empowers to also deal with intellectual property. And that has to do with customs, police, NAFDAC, and we also have the competition agency now that also has part of its mandate. There is something I just want to mention before I close in 2 minutes. I skipped it deliberately because I wanted to place some emphasis on it. So we've looked at licensing, franchising, and assignment. Key to IPR commercialization is mergers and acquisition. And I'll use examples of Udala and Konga and maybe Access Bank. Some years ago, Udala, who is the biggest, one of the biggest e-commerce brands in Africa, wanted to partner with Konga. And the fact was that Konga was a smaller brand. But Konga had very strong equity in intellectual property. They had built their trademark, they had built their brand names, so much so that by the time they were contemplating the measure, and they said, let everybody bring what they have on the table. Even though Udala could bring more things in terms of brick and mortar, but Konga was able to prove to them that his intellectual property was stronger. And it was intellectual property that was going to drive the market. And that whatever they had, they could replicate in terms of brick and mortar. And at the end of the day, it was agreed that true, Konga had a stronger intellectual property. And if the purpose of setting up business is to make money and to build brand equity and to galvanize the business, they decided to drop the Udala name and use Konga name. That is why you have Konga now. However, the real owners of the company are the Udala people. The same thing with Access and Diamond. Access is the most visible brand, but if you look at their logo is more of the old Diamond Bank because the Diamond logo is very strong. So you can actually see on all the branches that logo is more of a Diamond Bank logo, but it now has some bit of Access Bank. That is what it does. Therefore, joint venture specifically, there are so many IPs that are involved in joint venture. So many, because the parties that are coming on, each of them have their own intellectual property. For whatever it is what they must bring it to the table. And as they also come together, intellectual property is also produced as a baby from the joint venture. The question is that who has that intellectual property now that is collectively produced? Is it going to be shared collectively? Is it going to be shared by the brand that had a stronger, what we call background IP? Background IP basically is that the one that each person was coming with from his background. Obviously, one will be stronger than the other. Now they have combined and they have produced what we call a foreground IP. That is an IP emanating from both parties. So who is going to take the lion's share? How is it going to be shared? What is the future of the business like? All these things come into consideration. And if you're able to do it properly, you will discover that valuation, the law, and every other thing comes together to ensure that IP can be commercialized, be it for real estate and for any other goods, product, and services. I rest my case. Thank you so much.
Thank you very much, sir. We really appreciate you. You have really dealt with the issue that is both the law and the economic have to come together to really make IP a reality. And that is the strength of every innovators. And I think at the end of the day, we shall be having a kind of a more robust time that we can physically come together to do some analysis. Once again, thank you very much. I just want you to just stay a while the next person will take us on, then we can now take the question and answer together. You're welcome,
Thank you so much. Thank you, sir.
Yeah. I would like to move to the next person. Is a friend of the house too, and he has a wealth of experience in accounting. He has been a member of ICANN, a member of Institute of Strategic Management of Nigeria, Nigeria Institute of Management, Certified Pension Institute of Nigeria, Business Recovery and Insurance Practitioner of Nigeria, Equipment Leasing Association, a whole lot of, and is also the managing partner of Tunji Aino and Co. And as a pastor, married with children. I would like to welcome on board Mr. Tunji Aino to take us through the accounting and the IP valuation. Thank you very much, sir. You're welcome on board.
Good morning, Mr. Kilme. It's a pleasure being with you on this platform. Thank you so much. Thank you, Mr. President.
Thank you.
All right. Can you help me share my slide?
Okay.
All right. Basically, we are looking at accounting for IP and its economic values. Can you hear me? Hello?
We can hear you. We can
Yes,
hear you.
we can hear you. We can hear you.
Okay, just to be sure. All right, so we are looking at accounting for IP and its economic value. Sorry. Then move to the next slide, please. So intellectual property valuations. I'm not going to delve into the word valuations because that is your core area. So, but let's just look at one thing or the other in the area of valuation and how this issue of intellectual property should be viewed so that we can have a better orientation, better understanding, view concerning this IP that we are talking about today. The owners of IP needs to be able to effectively leverage on the knowledge, trade secrets, patents, technologies, technical know-how, trademark that they possessed. A lot of organizations, SME entrepreneurs, this slide or presentation will be focused in the area of entrepreneurship. So a lot of entrepreneurs outside there, they're into business, they want to make money and they want to affect their industry, but they don't have the knowledge of IP and how they can effectively leverage on it to better their businesses and at the same time to translate into economical value. Now, they need to understand the real value of the intangible asset and intellectual property that drives their success. And this knowledge ensures an active and informed approach to managing the intellectual assets, from valuing their IP portfolio to planning effectively for commercialization and growth. As intellectual property valuation experts, the focus should be providing high-level individualized service to startups and inventors as well as to corporate giants. So what we are looking at as per intellectual property is to make sure that both startup investors and even the corporate giants, they are well informed as per the word intellectual property so that they can take advantage on how to protect their property and at the same time convert it into economic benefit. The owners of IP needs to be able to effectively leverage. Okay, please, the next slide. So IP valuers are engaged to value intellectual property asset for financial reporting processes, including evaluation of value of naming rights, to measuring impairment of intangible asset for amortization purposes. So it is a function of the intellectual property valuers to be able to measure the impairment of an intangible asset for the purpose of determining the amortization process in order to report in the financial reporting. Then it leads to formalizing ownership of patents, trademark, copyright, and other intellectual properties that provide a barrier to entry for competitors, freedom to operate, and a market differentiator. Now, if I invent something, if I produce something, then I should be able to have a monopoly, to enjoy some certain monopoly until other people will come in. For example, if I've taken a lot of years and resources committed into research and development, and I've committed a lot of my time, my financial resources in inventing a particular product or publishing a material, wisdom demands for me that I should be able to enjoy a certain monopoly in order for me to be able to recoup what I have spent and what I've invested into coming up with this intellectual property. But if it is not well protected and other new entrant comes in, which are competitors, and because we play in the same industry and they have their own share, their own bite in the industry, and probably they have financial muscle than I do. So as an entrepreneur, they will outsmart me and they can leverage on my existing brand, leverage on my existing invention, my intellectual property, and there will not be any gain for me. So it is the function of the IP valuers to make sure that knowledge is imparted. People's eyes are being opened to see that their patent, their trademark, their copyright are intellectual property, and it has a better opportunity to give them a level of monopoly above their competitors and freedom to operate and give them market differentiation. Beyond the ownership benefits of formalizing intellectual property assets, there are a number of financial benefits as well, which we are going to see later. Patent, trademark, and copyright are assets with enormous benefit, and they can be used to support financial transactions just like any other asset. Now, we've been concentrating so much on physical assets like land and building, motor vehicle, equipment, and so on and so forth. And we concentrate on this to use it as collateral. But we have intellectual property which can be used for financial transaction, which can even be used as an asset that will give us a leverage, even when we are going into other financial transactions. So example of intellectual properties are patents, trademark, franchise or licensing agreement, goodwill. We're going to talk about goodwill because goodwill has its own peculiar way it is being treated. Copyright, a company's brand, trade secret. What are trade secrets? Now, if you look at Coca-Cola as a brand, up till now, can you hear me, please? Can you hear me?
We can hear you.
All right. So if you look at Coca-Cola, as a brand, up till now, nobody has discovered the secret behind Coca-Cola. And that secret is their trade secret embedded in their recipe. So designs and so on, these are examples of intellectual properties. Can we move on? All right. So intangible asset can also include internet domain names, service contracts, computer software, blueprint, manuscript, joint ventures, medical records, and permits. Brand equity. It is an intangible asset. Talking about brand equity, it is an intangible asset since the value of a brand is determined by the perception of the company's customers, and it is not a physical asset. So your brand is an equity. As we have share capital, which we have ordinary share capital, we have preferred share capital, we have bond. All these are capitals, but your brand also is an equity, which as an entrepreneur, you can leverage on. Reasons to value intellectual property. Number one, for transactional purpose. Evaluation of the IP portfolio is an essential component in the determination of the organization value to support a business sale. That is the purchase price when we have business combination, joint venture, merger and acquisition, or you are coming together in partnership. So your intellectual property is also good for transaction. Financing, patent, trademark, and copyright are assets that may be used as collateral to support a financing event. Evaluation is typically required to support the transaction amount and terms. For example, as a professional, if I say, okay, I want to use my brand, trademark for collateral, the question would be, what is the value of what you are bringing on the table? So the work of the valuers is to determine the worth of my intellectual property, which I can also use for collateral purpose. Tax planning and compliance. There are many tax planning and compliance situations that require valuation of intellectual assets, from relatively simple to complex. Now, when we are talking about firm, a small business, their whole intellectual property valuation will be a bit simple. But when you are talking about conglomerate, you are talking about multinational company, the valuation, the determination, and the measurements of their intellectual property will be a bit complex. But the truth is, intellectual property valuation can be used for tax planning purposes and compliances. Financial reporting. In a business combination event, identifiable IP assets are recorded at their current fair value. Evaluation of each asset is used to determine this amount. In certain instances, an annual valuation is required to determine if there is any impairment of the asset that will be required a write down of the asset. What do we mean by this? A financial statement reporting. We have PPE, which are equipment. These are physical assets that you can see. And we have non-current assets. And all that is non-current assets, we have intellectual property. So the services of valuer is needed on yearly basis in order to determine the current fair value of the IP to be reported on the financial statement. Having put into consideration if there are impairments on that asset. What does impairment mean? Impairment means weaknesses, deficiency, and the reduction in the capacity of such an asset to produce or to generate the expected economic value when it was acquired. So when an impairment is discovered, it will be written down against the value of the IP, and the resultant will be reported on the financial statement. And these are the work of the valuers. It is used also for this purpose, corporate and litigation. Public companies require IP valuation to support financial statement preparation and presentation. In litigation, the valuation of an IP asset and any related impairment to the asset are key to the determination of damages in the matter. Whether you are small or you are big, there are always litigation based on damages, maybe professional negligence or breach in contract. Please, can you take me to my slide? Hello, can you hear me?
Back to the slide, please.
Start.
I said they should take you back to the slide.
Yes.
Technical, please.
Because I want to concentrate on this without diverting my attention on other systems. Okay. All right. So let's move to the next slide. So key definition of intangible asset. Intangible asset is an identifiable non-monetary asset without physical substance. Now, what do we mean by this? It's like looking at an object that is made up of spirit, soul, but without a body. So an asset is a resource that is controlled by the entity as a result of past events, for example, purchase or self-creation, and from which future economic values, which is inflow of cash or other assets, are expected. Let me go by it. Now, intangible assets, they can be identifiable, but they are non-monetary assets. They are not physical. They are controlled by the entity based on two method or two by reason of purchase. So you can purchase an intangible asset, and at the same time, an intangible asset can be created, can be generated, can be produced over the time, and which economic future benefit, that is, inflows of cash or other assets, are expected. So later on, we'll look at the conditions that must be met for an intangible asset to qualify for intellectual property. Now, what is intellectual property in terms of capital? In terms of capital, some types of intellectual property are considered capital asset and may be recorded on company's balance sheet as intangible asset. Intellectual property is a fairly broad term and can be taken in many different forms. So let's move to the other slide. So your technical know, your human capital are also your intellectual property. Now let's look at this issue, and it calls for a serious attention when it comes to the issue of IP. Warehouses and factories are increasingly replaced by digital solutions as companies rapidly advance in technology capability. Thus, innovative ideas, research and development investment are a growing source of income for companies worldwide. Majority of developed countries and solid companies, they are going digital. They are going into full technology. And it calls for a serious attention, especially for the valuers of IP. So they raise ideas, and the result for knowledge, for creativity, are emphasizing the increasing role of intangible assets and the need to quantify them. In those days, we have been called agrarian generation. But now we are in the age of technology, and so many inventions, discovery is coming up. So the of valuers. So some intangible assets are protected legally where they meet the criteria for intellectual property protection and right. As we heard from the first lecture, it is not all inventions. It is not all your product, your services, your logo that can be patentized or copyright, that you can have trademark, or you can have license on this, except it meets some certain criteria. So intellectual property rights are often granted for innovative products and processes, cultural, literary, or data software works, copyright design, and so on and so forth. The next slide. Technical, the next slide. So the accounting standard that specifically dealt with IP is IAS 38. And I want us to be concentrated in this area. Even though you might not be an accounting person, I will see how I can break it down so that we can all be carried along. I repeat again, the IP and the IAS that dealt specifically with IP, or let's say intangible asset, is IAS 38. What are the objectives of IAS 38? Number one is to prescribe the accounting treatment for intangible assets that are not dealt with specifically in another or other IFRS. So IAS 38 specifically look at intangible asset and dealt with it, how it should be treated in the time of recognition, measurement, disclosure, presentation, which we are going to see in the other slide. So the standard requires an entity to recognize an intangible asset if and if only certain criteria are met. The standard also specifies how to measure the carrying amount. The carrying amount is also mean the net book value. That is cost minus depreciation or amortization, and the resultant is the carrying amount. So intangible asset certain disclosure regarding intangible. Can we move on? So scope, IAS 38 applies to all intangible assets other than IAS. So let's move on. Let's leave all this one. Let's move on. Let's move on. So critical attributes of an intangible asset are, there are 3 attributes and they are critical for an asset to be classified as an intangible asset. Number 1, it must be identifiable. If you cannot identify an asset, you cannot classify it into intangible asset. So though intangible asset is not physically touched, it's not physically felt, but you can identify it based on some parameters. Number 2, control. Who control this asset? If you cannot attach a controlling power to a particular asset that you term to be an intangible asset, then it doesn't qualify for an intangible asset. I should be able to say I have control over this intangible asset as an IP property before I can say, okay, I can recognize it. Then number 3, it must have future economic values. It must have future economic benefits such as revenue or reduce future costs. So if I cannot generate future revenue, if it is not probable, if it is not certain that in some years to come, what I call intangible asset will bring revenues to me or reduce some certain future costs, then it does not qualify as intangible asset. So what is identifiability? An intangible asset is identifiable when it, according to IS 38, line 12, is separable, that is capable of being separated and sold, transferred, licensed, or rented, exchanged either individually or together with a related contract. So it must be transferable. I should be able to rent it out, and I should be able to exchange it, and I should be able, it should have a contractor, contractual or other legal rights, regardless of whether those rights are transferable or separate from the entity or from other rights and obligations. Next. Means by which intangible asset can be acquired. Intangible asset can be acquired through by separate purchase. When you buy a business combination, when partners come together, you can acquire IP, which is the same thing as intangible asset. By a government grant, if government give me a grant, for example, royalty, mining or exploration, right? Then that means I have been able to acquire some intangible asset, because that right, that grant that have been given to me, it could even be more. For example, look at it. If that grant is not given to me, I will never have access to exploit or to mine such mineral resources. So that grant alone carries value. So by a change of asset, that is over the time in your business operation, you can generate internal IP. All right? Are you following me? Are we together?
We are together.
Hello?
We are together, sir.
We are with you, sir. We are listening.
Hello? We are with you.
Daniel.
All right. Just to be sure.
Yes,
I'm not just speaking to the ear.
We are very much with you, sir.
Okay.
You are doing great,
All right.
sir. Thank you, sir.
Thank you. Thank you. Thank you, sir. So let's move to the next slide. So recognition criteria. You know, I said, we'll be looking at recognition, measurements, disclosure. So recognition criteria require an entity to recognize an asset, that's the intangible asset, whether purchased or self-created, which is at cost. If and only. So before you can say, okay, I want to classify this asset as an intangible asset, as IP, it has to follow this criteria. Number one, it is probable that the future economic benefits that are attributable to the asset will flow to the entity. So the future economic benefits that will flow to another entity, I mean an organization, I can't claim it. It must be probable, it must be provable, it must be certain before I can say this IP belongs to me, that the future economic value benefit will flow to me as an entity. Number two, this applies whether an intangible asset is acquired externally or generated internally. So the probability of future economic benefits must be based on reasonable and supportable assumptions. You cannot just, before you can say this thing is probable, you must have supportable assumption, which you must be able to prove. Let's move on because of our time. Under recognition, if recognition criteria are not met, then it does not meet both the definition of and the criteria for recognition as an intangible asset. So an intangible IAS 38 requires the expenditure on this item to be recognized as an expenses when it is incurred. So any expenses that you incur and does not meet those certain criteria, then it must be expense. It should not be capitalized. We are going to look at this when we are looking at how you can capitalize your expenses to become your asset. So business combination, that is a presumption that the fair value and therefore the cost, which is of an intangible asset as acquired in a business combination, can be measured reliably. An expenditure that is included in the cost of acquisition of an intangible item that does not meet both the definition of and recognition criteria for an intangible asset should be form part of the amount attributed to the goodwill recognized at the acquisition date. You know, goodwill is an intangible asset, but does not appear on the financial statement. We are going to look at it because it falls under indefinite period. So how do we reinstate? On IAS 38, we have looked at recognition. What factors and criteria that must be met before you can say this asset is recognized as an intangible asset, which is the same thing as intellectual property. So let's look at reinstatement. IAS 38 dealt with a reinstatement of intangible asset. The standard also prohibits an entity from subsequently reinstating as an intangible asset at a later date an expenditure that was originally charged to expense. If I had charged a cost to expense, I cannot reinstate it at a later date. That is the standard on IAS 38. Initial recognition. How do I recognize my cost on research and development? Because research and development makes volume part of our IP. Your research and development, they are intangible assets. You incur, you know, some companies, some businesses, before they go into physical establishment, they have gone into several research and development because they knew that the outcome of their research and their development goes a long way in sustaining their business, not today, but into foreseeable future. So you cannot erode such a cost. And this cost as a way it's being treated. So charge all research costs and expense. Development costs are capitalized. That is, it is taken as an asset if only after technical and commercial feasibility of the asset for sale or use have been established. So this means that the entity must intend and be able to complete the intangible asset and either use it or sell it, and be able
Hello? 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 Please, can you hear me? Hello?
We can hear you, sir.
Yeah, I think we just lost Mr. Aino. While we are waiting for him to reconnect, maybe we'll take some questions on what Mr. Nusa has delivered this morning, so that we cannot just have to move on. I would like to recognize our second vice president. I'm just seeing him on the board. You are welcome, sir. We really appreciate your presence. Thank you for coming, sir.
Thank you so much for the good work. I appreciate it. Sorry I joined
Thank you,
late,
sir.
but I'm enjoying everything. Thank you so much.
Thank you very much, sir. Do we have any question for Mr. Nusa? Let's start with that, while Mr. Aino will join us later. Question from the participants. Oh. Hello, Mr. Nusa.
Yes, sir.
Yeah, let me put you on this. That
Yes.
when we talk about infringements,
Yes, sir.
at what point do you think valuation report is necessary before you file in your suit?
For infringement actions.
Yes.
What I will always tell people is that it is during the time of peace that you prepare for war. So what that automatically means that if you are an establishment and a growing concern, and like we've been saying since, that you think that the purpose of doing business is to sustain the business, especially if you are put in a position of leadership or authority in that business, and you're supposed to be held accountable. You would always envisage that things like this would happen. You know, infringements are always twofold. One is somebody comes to infringe, and another thing is that you too. Yeah. Hello?
I'm back.
Okay, Mr. Aino, you are welcome back.
I'm sorry, network issue, please.
Okay. So, Mr. Nusa, we'll come back to that question so that we can also take it, so that we look at the importance of the valuation aspect and the work of the jury in order not to rob the property owners. So, Mr. Aino, you have the floor now.
Sorry. All right, can I go back to my slides?
That's the technical itch. Yes.
Let them take me to my slide,
Slide,
please. All right.
Please. Yes, they are taking you to your slide.
Let me start. Yeah, let me quickly say I can rush this in because of time. So let's move to the last statement. If an entity cannot distinguish the research phase of an internal project to create an intangible asset from the development phase, the entity treats the expenditure for the project as if they were sorry. Next slide, please. So initial recognition in process research and development acquired in a business combination. A research and development project acquired in a business combination is recognized as an asset at cost, and even if cost expense except the extent that the expenditure satisfy the criteria in IAS 38 for recognizing such expenditure as an intangible. So what this issue of recognition is talking about how we treat initial cost, how we recognize it. Is it going to be capitalized? Is it going to be expense? So when an expense does not meet, a cost does not meet some certain criteria, you expense it into profit or loss account. And if you meet those certain criteria, then you capitalize it into your balance sheet. Can we move on? Let's move on. Let's move on because of our time. Let's move on. Let's move on. Let's move on. Let's move on. How do we measure intangible asset? When I have recognized, then I must be able to measure. The word measure has to do with valuation. So initial measurement, intangible assets are initially measured at cost. That is the basis for measurement. Other method of valuation or measurement can take place later on. But initial measurement, when I want to determine the value of my intellectual property or intangible asset according to IAS 38, line 24, the initial measurement has to be recorded at cost. So measurement subsequent to acquisition, you can either apply cost model or revaluation models. So an entity must choose either the cost model or the revaluation model for each class of intangible asset, and it has to be disclosed. I have chosen cost model for the valuation. This particular intangible asset, I have chosen revaluation model for the valuation, for the measurement. So cost model, after initial recognition, intangible assets should be carried at cost less accumulated amortization and impairment. Amortization is the same thing. It's not the same thing, but it is another word used for depreciation. You use amortization for intangible assets, such as our intellectual property, while we use depreciation for the tangible asset, our PPE. So valuation model, intangible asset may be carried at a revalued amount based on fair value, less any subsequent amortization, as I've said, and impairment. And impairment are losses, deficiency in the cost of the asset that you are carrying. So when you are applying revaluation model, you will use your fair value less any subsequent amortization and impairment losses, only if fair value can be determined. Before you can use evaluation method, that means your fair value must be determined by reference to an active market. You cannot use a revaluation model in isolation. It has to be backed up with active market. That is, the players they have knowledgeable of the market, and there's no anyone that is under duress. Such active market are expected to be uncommon for intangible assets. Can we move on? Can we move on? Let's move on. So classification of intangible assets based on useful life. We have intangible assets which are classified as indefinite life. So that is no foreseeable limit to the period over which the asset is expected to generate net cash inflow for entity. And the other one is finite life, which means a limited period of benefit to the entity. So your intangible assets are classified into two broad categories. indefinite and definite. If it is indefinite, that means you cannot predict the lifespan. But when it is finite, that means you can determine the economic future benefits based on the lifespan. So measurement subsequent to acquisition, intangible assets with finite lives. If you can determine the lifespan, that means the cost less residual value. What is residual value? Residual value is the value of the assets you are carrying over at the end of the expiration of the lifespan. So with finite useful life, you should amortize on a systemic basis. I think let me just summarize this slide so that we'll not be wasting our time. Now, you measure your intangible asset if it is finite lives. That is, you can determine the years. So you, for example, if you have an asset, maybe software, for example, and you say, okay, within 10 years, this asset, this intangible asset will have been fully utilized. That means it is finite. But if you have an asset that you cannot determine the lifespan, it becomes an infinite asset. Can we move on? Let's move on. Let's move on. Technical, let's move on. Let's move on. It's okay, it's okay. Measurement subsequent to acquisition of intangible asset with indefinite useful life. An intangible asset with an indefinite useful life should not be amortized because you cannot determine the lifespan according to ISA 38, line 107. So its useful life should be reviewed each year of reporting period to determine whether events and circumstances continue to support an indefinite useful life. So assessment for the asset, if they do not, the change in the useful life assessment from indefinite to finite should accounted for a change in accounting estimate. Now, if you determine or it is discovered that at a certain period of time, this asset becomes definite, then you have to disclose it under IS 38, line 109, that this asset is now regarded as definite. So the asset should also be assessed for impairment according to IS 36, which is the same thing as IS 38, line 111. On yearly basis, you must test your asset for impairment. As I've told us, impairment has to do with, let me use the word deficiency, the word weaknesses that will not make your asset to perform at maximum expected state, and it will not be able to generate you expected economic value. Let's move on. Let's move on. Subsequent to expenditure, let's look at that. Yeah, due to the nature of intangible asset, subsequent expenditure will only really meet the criteria for being recognized in the carrying amount of an asset. Subsequent expenditure on brands, publishing titles, customer lists, and similar items must also be recognized in profit or loss as incurred. So you don't capitalize this once it doesn't meet the criteria for capitalization. Let's move on. Let's move on. So disclosure in financial statements, there is a body that governs or that regulates every professional that has one input or the other in producing financial reports, which is called Financial Reporting Council. So Financial Reporting Council recognizes all professionals, whether legal, accounting, essay surveyor, and the likes. So in financial report, valuers must also declare under the note of the account that this and this and this. So for example, the disclosure that must be made when it comes to intangible asset is that for each class of intangible asset, you have to disclose the useful life or the amortization rates, method, and gross carrying amount, and the likes. The additions, that is when it comes to business combination, you have to separate it. Asset held for sale. Asset held for sale are the assets you are holding as an organization. They are meant for sale, not for day-to-day use to generate funds. So retirement and the likes, basis for determining, you have to disclose it. The additional disclosure are required, which talks about intangible asset carried at the valued amount. Every year, we normally concentrate on physical evaluation of property PPE, but on yearly basis, intangible assets should be revalued to determine the economic value of that asset and to test for impairment. So the amount of research in the current period, let's move on. Let's move on. Let's move on.
Sorry,
Without
Mr. Eno, can you just round up in the next
Okay. So with that IP,
2 minutes so that we can
right,
have other one question and
all
answer.
right. Asset is not fully recognized. Without IP, asset is not fully recognized. As I've been rounding up, because of our time, IP strategy should be married with your business strategy. And we must look at how we can.
All right. Thank you.
Use
dinner?
our
What of dinner? What of dinner?
drive our business.
Can you mute your mic, please?
Our IP to drive the economic benefit that flows into, hello? Yeah, there are background sound.
Please mute.
Can you hear me now?
Yes, we can hear you.
Hello?
Go on, sir. Go on, sir.
So as I'm rounding up, I said as I'm rounding up in the economic benefits of IP, as valuers and as entrepreneur, as service provider, we must look at the economic value aspect of intellectual property. We must allow our IP strategy to drive our business strategy, and we must allow our business strategies to drive our intellectual property strategy. And as we are building our businesses, we must make sure that we give attention to our IP, because if physical assets fail, intangible assets will sustain our businesses, even in the area of serious challenge, even the area of pandemic, in the era of whatever negative consequences that befalls businesses. Brand stand, IP drives business, even in the era of challenges. Thank you for giving me this opportunity. The slide is available for us. We can as well go through it at our leisure time. Thank you, sir. Bye.
Thank you very much, sir. Don't go yet. We still have some questions for you.
All right, sir.
I would just want the third person to quickly deliver his paper. That is in the person of Essence of and Value, Yomi Pishola is going to talk about standard. I know that one will take time so that we now wrap up the whole thing and then we have our questions. We have one question in the box already. Then
Good afternoon, everybody. Hello, my chairman.
Good afternoon, sir.
Do I have my slide shared? Good afternoon once again. Much appreciation to the chairman of this faculty for the way it's moving.
if you have other questions, you can just put it in the chat box.
And for organizing this type of summit, which are continue to go from strength to strength. The last speaker have, in a way, resolved most of the things that we have to discuss under standard, particularly as regards the IAS, International Accounting Standard, which has to do with financial reporting. So I'll be limiting myself to International Valuation Standard and the International Public Sector Standard. Next slide, please. By the way, what we are just to do,
Thank you, sir.
discuss here is just very, very minimal, like I said. Next slide. Now, like the two speakers said, we're in the era of globalization to the extent that many things has to change if assessors and valuer they want to be evolved, want to be a partaker of the largesse. And as such, we'll just be looking at this discussion interactively, believing that one way or the other, we have an idea of what we're talking about. And the reality is just that the intangible assets, which are described as IAS here, has been in existence for quite a while, since the beginning of the creation. Look at the cave dwellers. They have an idea to create a cave. The creators of calendar, creators of alphabets, creators of numbers. But unfortunately, these things were not patented, so they were not easily recognized as I today that do we even qualify to call intellectual property assets because they cannot be seen, they cannot be touched. Are they actually assets? So I therefore want to give us the definition of what an asset is here. Definition of what an asset is. According to the Webster Collegiate Dictionary, assets implies the entire property of a person, association, corporation, or estate applicable or subject to the payment of debt or as an advantage for resources and is a chief asset. And according to Financial Accounting Standard Board, asset is defined as a probable future economic benefit obtained or controlled by a particular entity as a result of past transaction. By the virtue of the last two presentations, we all believe that what we are so much after is the crucial economic benefits of this asset. And if we all agree that based on their presentation, intangible assets actually qualify for this, so to water down those questions, intangible assets are actually assets that has economic benefits and that can be quantifiable, that can be valued. Next slide. The lawyer in the house did a bit of graphical formula, which like is an equation here. The asset is equal to tangible plus intangible assets. And tangible assets are those ones that we can feel, that we can see, that we can touch, that we can do different things like our land and building, plant and machinery, motor vehicle, etc., etc. While intangible assets, following the International Valuation Council definition, committee definition of 2014, and as presented by last speaker, to a non-monetary asset that manifests itself by its economic properties. Scarcity is there, control, ownership is there, and the identifiability, I said other times, also there. It does not have physical substance, but grant rights and economic benefits. But this intangible asset is further classified into two, into both identifiable and non-identifiable intangible assets, like our copyrights, our trademarks, our patent, our design, our trade secrets are identifiable, and they are recommended for violation at every point in time. Those are not identifiable goodwill, the capital, the big market. You can say somebody has a big market, it's selling fast. Was that converted into brand? And that somebody has high profitability. Does it have a brand? Is it not that something that will, like the last person presented, something that will wait off over time, that at the end of the day will to be treated as an expenses. The next slide. And what is valuation standard? What are valuation standards? These are established, recognized, and accepted guidelines for best practices in the conduct of professional valuers to ensure, number one, reliability, effectiveness, and transparency in their valuation services. Like I said the other time, we cannot afford to just be doing things wishy-washy because of the global connection, so that when an expatriate is to do a valuation here, they will not be inviting a professional from another country. So we need to actually look at what the standard is saying. The essence is to achieve consistency, acceptability, reliability, and uniformity. And next slide, please. The first standard I'll be talking about is the International Valuation Standard, which has been replicated in our own green book with the valuation practice guidance attached. We have it on our table, but for the purpose of this summit, we need to expose ourselves to some some of the provisions regarding intangible assets. International Valuation Standard Committee was founded in 1981, and presently we have about 138 member organizations with more than 340,000 individual members that are qualified. The good thing here is that ESVABON is a member of the body, and ESVABON regulates the practice of asset surveying and valuation. And as of today, based on our last interview and some other things at the level of ESVABON, we have more than 5,000 registered asset surveyors and valuers. The fact is, this is still very low as compared to Nigerian population, and the real estate and other property activities are coming up. We are just hopeful that we'll be improving on a daily basis. Now, what does Ivy says about intangible assets? The next slide. We may need to ask a question here, that what does Ivy says about intangible assets? The next slide, please. Hello? The next slide.
Mr. Omo, next slide.
Okay. The particular standard that is talked about intangible assets under the International Valuation Standard is the IFS 201. And there are 11 paragraphs in this case. We have from paragraph 10 to 10. And the definition I gave the other time was actually available in paragraph 20.1. And 20.2 says that intangible assets, there are specific intangible assets which are defined and described by characteristics such as the ownership, the function they perform. For instance, your trade secret, like last speaker said, Coca-Cola has a trade secret that today nobody can just imitate. The market position, the image you have, these are the characteristics that differentiate different types of intangible assets. I have a senior colleague that anywhere I see Wole Soyinka's picture, he can pay an amount of money to pick a portrait. Those are the things that differentiate the function it performs in his own mind and the image that such things give him and give people at large. That is why he's ready to pay an amount for such a portrait. The next slide. And this standard also try to identify different types of intangible assets that are available. And that is available in paragraph 20.3. About 4 of them were identified like that. You have those that are marketing related, those are in customer or supply related, those are artistics related, and those are based on technology. You all agree with me that all these are actually what promotes majority of the company now. I mean, the recent time, most especially when this COVID issue arises, we discover that most things were not done physically. So some of us will be in the known of what money those people that has innovation are making. So those are the types of intangible assets that were recognized by international valuation standard. And what are the criteria? The next step to actually qualify them for valuation. What are the criteria? The next slide, sir. Technical. Do I use my own slide? The next slide. The qualification criteria for IP to be able to be valued is that of number 1, separation. You should be able to separate if possible. You can still be running your company. Yeah, you still be in the control of the company. Royalty. Those are the things that has to do with how they perform. The kind of contractual obligation they have too. You should be able to at least be able to define what level of contract obligation do we have. Is it for definite? Is it for indefinite? The legal rights and protection they have. Some of these IPs and intangible assets actually have lifespan. They have lifespan, and this lifespan has to be identified. The copyright, I think, is about 70 years or so. The trademark also has its own limitation. And the purposes for which intangible assets can be valued are so many. Many of them have been. Next slide, please. For financial reporting, it's one of them. To the extent that when you are preparing a balance sheet or the financial statement of a company, the involvement of, inclusion of intangible assets should be monitored and it's necessary. For tax purposes, public sector assignments, transactions and floating, an example of that is merger and acquisition. Example is being made of the other time of Diamond Bank and Access Bank. That's a story for another day. Unfortunately, one of them shot herself in the leg without properly valuing IP for presentation for negotiation. The fairness opinion, banking arrangement, insolvency administration, portfolio review, and some other. The basic fact is that any type of purposes, any kind of purposes you can use tangible asset for, you can value tangible asset for, you can also value intangible asset for, and there are many as they are available in literature. So what are the basis? As the basis as provided in International Valuation Standard 104 is also still being observed under intangible assets. And we have them from paragraph 20 to 120 when well explained. And those bases are fair value, fair market value, open market value, and the likes as mentioned here. I didn't want to waste our time. Sorry, I'm being fast so that we can actually engage properly our visitors under question and answer. And the methods, some of those methods has also been discussed too. But I just want to say that the other three major methods that we use for valuation of tangible assets are also the three methods that are applicable under the intangible assets. We have market approach, and you can see reference it in under paragraph 20.2 and 20.3 of IFS 105. Income approach is also a method being used, cost approach. And all of them has their advantages and their disadvantages. For instance, where there is no data that's available, when the IP or the intangible asset has not been generating money, revenue, one will be forced to resort to a cost approach. Or when the intangible asset is still at as a young stage, which it has not been fully commercialized, and so there's still for us to determine the value of, to value it, we'll be forced to recourse to to cost approach. Income approach has its advantages, the fact that it actually measures the benefits that comes to the owners of the IP or the users of the IP, as the case may be, or the intending purchaser or lessee or franchisee of the IP. So those are the methods that are recognized by international standard evaluation. But I must say that under the income method, all the income methods that we use to value our tangible assets are also very, very applicable. Like our discounted cash flow method is also very, very applicable. The profit method, even to the level of our royalty method, our cash flow analysis, the sensitivity analysis. And what this one is telling us as a surveyor and valuer is we need to scale up our knowledge beyond all these three method or major methods. We need to scale our knowledge so that, because at a particular point in time, you will be required to do evaluation of intangible assets, and you need to determine the risk. All these three methods will not allow you to determine the risk. It shows that you need to know about method that has to do with sensitivity analysis, risk and analysis, and some other methods like that determine risk. So I will move quickly to IPSAS, the International Public Sector Asset Standard. I want to appreciate the accountant in the house for having treated the financial reporting standard to a very large extent. This one is also related to accounting, but it's basically for public sector. And that is why I've picked financial valuation standard and also pick this one to discuss. It has a board, and like I said, they are just basically for public sector of financial reporting standards. Financial reporting standard, like I said, applies to private, but this public sector standard applies to public entities. The standards will call, the financial reporting standard will call companies, we mentioning companies, while public sector standard, we mention entities because they are private, they are public entities. As at end of 1999, the first 8 IPSAS were issued, followed by another 6 in 2000. But as 2016, there are 39 IPSAS. And how are they applied? Next step, next slide. They are, like I said, they are designed and approved to be applied by public sector entities. And as valuers, most of us that were in Lagos, if one of us were fortunate to be involved in the Lagos State IPSAS evaluation, if we have shortchanged Lagos State or we've done well now, it should strike our mind to know that, to say that, do we ever identify intangible assets for Lagos State, or when we identify, do we value appropriately? As a matter of fact, sometimes you still get to that. Sometimes even the owner of the IP doesn't know that they have the IP. I quickly give an instance. As a senior colleague that was engaged to value one of the best pharmaceutical company in Songo and in Nigeria, but located in Songo, it just fell within him that these people should have an IP. But the only method the old man knew then was the profit method. And he therefore asked the accountant of the company, can I get your profit for the last 10 years? Behold, the man was giving 3 years losses. So by implication, they didn't have a goodwill or an IP, and that is very, very wrong. The fact that they didn't have profits for those periods doesn't make that they didn't have IP. So that is part of the problem we do encounter. So they are designed for public sector that deliver services to benefit the public or to distribute income and wealth, and there are many finance activities by means of taxes. All our public sector, they finance the activities through taxation we all paid. And if there is need for them to transfer from one agency to another agency or from one entity to another entity, it requires that they apply IPSAS. And basically, when they didn't have the intention to make profits, so IPSAS is readily applicable. Next slide. So the applicable IPSAS for intangible is IPSAS 31. And the pronunciation of IPSAS 31 was based on International Accounting Standard 38. Just that one is more of private now than why this one is more of public. And the effective period was April 1, 2021. So let's look at qualification for intangible assets under IPSAS. Next slide.
5 minutes to
Next
go,
slide,
sir.
please. Okay, sir, I'm with you. So,
Thank you.
like I said, IPSAS and IAS are more or less the same thing. Just that one is for the public, and the other one is for the it's for the private. Next slide. The method is that is applicable under IPSAS. The method that is applicable under IPSAS are cost model, and which is the formula is that they are being carried at cost, less any accumulated amortization or impairment. Impairment and amortization are more or less the same thing. Impairment is saying that an asset is reducing in quality, in quantity, in value. So that is cost model. The evaluation model, you can only use this one when there is an active market. For instance, when the activity is quoted and you can actually identify, it's just like we are using our market comparison method, so that I can be able to actually identify the indices in the market. So if that is not available, you resort to cost method. Under the evaluation method, asset is carried at a revalued amount, which is fair. This is fair value at the revaluation date, less any subsequent depreciation and any subsequent impairment losses. If there's any deduction, as for instance, if the stock is being sold at ₦1 per unit, and it now became some kobo per unit, then an issue is already happening. So you take care of that. So what are the challenges generally for valuation standard, either that of financial valuation standard or federal, financial reporting standard? or the IPSA standard. The acceptance level of regulatory bodies is a bit low in some areas, in some states, in some of these members' organizations. And even when they accept, the issue of enforcement was also very, very low. That has to do with acceptance. But it's ordinarily assumed that what you so much desire and you pursue and you get it, you always try to protect it. Then the next one is the increasing complexity of the financial markets. Things are changing every day to the extent that different indices are coming up, and the financial market itself is not stable. So that also affects the application of the standard. The expanded uses of fair value. Fair value now are being used for different purposes. You want to do a merger, you want to look at what is fair. You want to discuss in court, you want to look at what is fair, even if it's not going to be totally open market. So all those things are part of the challenges of application of standard. The evolving business environment too, the globalization is an issue. So what are the way forward? What are the way forward? Number one is we just have to continue educating ourselves like we are doing now. We cannot stop educating, we continue to educate ourselves. Our regulatory body has to engage in compliance, enforcing and encouraging our members to apply this standard so that the food will not leave our table to another professional table. Then we need to review this standard on a regular basis. It is very, very important. The conclusion, there should be collective demand of principle-based technical framework that will improve the global standing of valuations specialists and lead to a greater level of consistency in both methodology and documentation of valuation. Our reporting standards, our process. I forgot to tell us, and though we know that valuation, like we know, is a process of developing an opinion. So if it's a process, it shows that we need to be careful from stage 1 to stage 2, so that at the end of the day, we're going to have a palatable product, and that will give our clients in the society, in the market, confidence that we have valuers. The next slide. So this is the time that we have the opportunity to raise the standard of valuation and get the good nod of our clients. And the best time to do that is now. There's no need for us to be postponing. And finally, it is not enough for us to know we must apply. Willing to is not enough, we must do. Thank you.
Thank you very much, sir. We really appreciate your time, we appreciate your thoughts, and we appreciate the discussion. Thank you very much. Quickly, I would like us to look at what we have as a question and answer. We have a question here saying that the question is to the accountant. Is Mr. Eno still in the house? Mr. Eno? Okay. Can you unmute Mr. Eno, please?
I've done that.
Okay, the question is to you, sir. My question is, how have accountants been able to measure intangible assets in the process of annual financial reporting or merger?
Yeah. Basically, it is not a common or frequent valuation when it comes to intangible assets. But basically, for example, in year in, year out preparation of financial statements, oftentimes the issue of asset is not well given attention to. And I'm very, very glad because of what is even going on presently now, because I believe a new orientation is being formed, probably a new body that will look at this issue critically is going to be given back to. So oftentimes, when we normally concentrate on when it comes to the issue of intangible asset is the area of merger and acquisition, business combination, joint venture, specifically how to determine intellectuality or intangible asset is in the area of purchase consideration and the actual value of the actual value of the physical asset. Now, if my actual value of the physical asset is, let's say, $1 billion or 1 billion naira, but the purchase price is 2 billion. So there is a difference of 1.5 US dollar. That means what we are paying for is an inherent value that couldn't be seen physically. So this 1.5 billion is the inherent value, the intangible asset that we are paying for when it comes to the valuation or the reporting on the financial statements.
Okay, thank you very much, sir. I would like Mr. Nusa to conclude on our last discussion about the infringement so that we can give ourselves a more enlightened information about how to tackle infringements and what are the necessary documentation towards that.
Okay,
Mr.
thank
Nusa,
you.
please.
Thank you so much. I would like to say that valuation is required at every point in time for, like we have been saying since, for any brand that wants to grow and any company that wants to have a future. And I'll paint two clear scenarios, maybe two. One in terms of litigation, one in terms of you also know that a lot of intangible cases, where in Nigeria now, you have situations whereby your rights are infringed. And having identified the rights and having identified the party, the question is that you have to write a cease and desist letter, which is basically just to tell the person that you should stop infringing or whatever. But the question is that we've had several occasions where by the time you are now called, I mean, the person doesn't want to go to court in some cases. You have to put a value to the IP in your discussion. So, like I said, it's ab initio. For every company should have an IP strategy that audits, that values, that wants to explore. That should be part of your business model as a company. And that's what we have been canvassing. It's not that, and it should be part of what the board should ask when they're asking that, look, or that when you are putting this thing together, don't just bring roof and factory to us. Tell us how much IP are you likely to generate? And like we have been mentioning since, what is the future value of this your company? What if the building gets burnt and you don't have anything again? Does it mean that you don't have an intangible? Like our accounting, our polytechnic lecturer said, that you have a pharmaceutical company that has been going on for years, just because they have not been making any money, you say they should probably put some values to them. And the accountant is saying there is no value. I mean, that accountant should be looked at very critically. And so you discover that when you are going for such discussion, it is proper that you go with a document that actually shows an empirical valuation of your IP. Whichever IP that has been infringed upon, you should be able to show. Unfortunately, most times you go in there and just discuss. Even when in some cases you tell your client that, look, okay, let's create a value around this thing. You discover that it's like you are speaking Greek to him, because in some cases he doesn't even know where his IP started from. He doesn't know where it is. So you have to go through that process of putting a figure to it. And so that is why this type of discussions are very important. That look, at every point in time, IP valuation is required so that when the push comes to shove and issues of infringement come, it is not then you start quenching fire or you start rushing up Now, if you have a periodic of your hello,
Yeah.
if you have a periodic assessment, let me round up, please. If you have a periodic assessment of your IP, then it means that at every point in time, you can actually show an empirical value based on accounting standard. Then, secondly, if you are filing your writ in court or whatever, when there is an infringement or any other thing, it is proper that you also put in the actual value or the value that you have ascribed to your intellectual property based on accounting standards. So it's something that is always required as long as the business continues to exist. So that's where I will stay for now.
Thank you very much, Mr. Nusa. There's a question here that say, to Mr. Eno now, and Mr. Nusa will follow after. He's saying that have you engaged SS and Valua in the past concerning the IP valuation? Mr. Eno.
Okay. I mean, as a body or as an entity, a professional entity.
As an individual, maybe you are on a particular job, and then there's a collaboration that you now have to ask them to have an input, especially on the IP side.
Well, I've not actually collaborated as an individual, but we have some of our entities that we audit. Probably they have their own in-house essay surveyor and valuer, or they just engage that the valuer might not be on retainership with them. They outsource, they engage the professional, and they pass the evaluation report to us. For example, we did one of recent, audited by one of a renowned essay surveyor and valuer, maybe like 3 months ago. So they pass it to us, and we use it to prepare our report. And that's the reason why I said this platform is very good, because both the accounting profession, industry is going to bring a serious enlightenment. And by the time the business owners' eyes is being opened to the issue of intellectual property, I believe it's really go a long way. But as a person, I might have not collaborated with essay surveyor and valuer specifically. But for example, some of our big clients, we rely on the essay surveyor and valuers report. So
thank you very much, sir. Because of our time, I would like Mr. Nusa to react to this. Is our business environment ready for IP commercialization?
The truth is that it is not whether the business environment is ready or not. Like we have been hearing since, it has become very necessary, because a lot of things that we lay hold on before are becoming anachronistic. You heard that the lecturer said that everything is going digital. Every business is going digital. People are even running from brick and mortar. ShopRite did not come to Nigeria with any brick and mortar, but see how much they have made from it. So if you are a serious-minded business owner, it will catch up with you. So the business environment might not be full-blown now, but people are gravitating towards it very serious. And in all financial statements, and you are beginning to see the discussions like we're engaging in now, you discover that in the next 10, 15 years, you discover that IP will be on the front burner. It will be discussed at every board meeting. That is what we are fighting for. Let it be discussed at every board meeting. It shouldn't be an afterthought. Thank you.
Thank you very much. In 1 minute, I want Mr. Essence of Value Yomi Bishola to react to the scale of fees. How do we go about it? Because it's a new area that people are looking at it, that maybe the fee will be so huge. What do you have to say to that before we close now? Our time is spent.
Well, it's new. But I want to thank God that the chairman of this board, in the person of Niesv Lekon Akumi, is a member of ESVABON, the regulatory body of our profession. that determine, in conjunction with federal government, what we earn for each of our services. So there's also the need for what this one is telling us, that we need the review of our scale. That is just a simple answer. There's need for the review of the scale of professional charges, so that properly and directly we are going to have how much, what percentage at a what a graded scale that you earn if you do violation of IP. Don't forget that most of the things that we do under IP now are more of litigations than buying and selling or franchising. So it's important for us as regulatory body to also have our scale updated to include violation of IP. Thank you.
Thank you very much. I can tell you that the scale is already in the pipeline. The board is working on it. So this, as Mr. Eno, we close. What do you have to say to a manufacturing company that doesn't put intangible assets on their balance sheet? What do you see to that?
Well, they are shortchanging themselves, because that's the truth. The physical assets, the machines, the raw materials, they're in one part. But the image, the brand that have been built for several years, for not putting it, for not valuing it and recognizing it on yearly basis, they are shortchanging themselves. So I want this issue of IP to be well crusaded, and let's bring it to serious awareness. I mean, in fact, thank God that I'm part of this discussion today. It has really broadened my understanding and my horizon. So I want it to be well crusaded, so that people's understanding will be more broadened. And you know, the more people are aware, the more job and services that comes to value us. Thank you, sir.
Thank you very much. As Mr. Nusa is rounding up, what do you have to say concerning IP of development in Nigeria?
I didn't get that, sir.
What do you have to say to IP hub development in Nigeria?
IP hub.
Yes.
HUB.
Yeah.
Yeah, HUBS.
Okay, HUBS.
Yes.
I think it's still in its. I've not really heard so much about it. But yes, it's still at its formative stage. But I think that whatever can be done now to generally galvanize attention towards intellectual property is required. I think we should all support it. Whatever. I mean, one thing is that you can see from our discussion that IP is multidisciplinary. No discipline can exclusively claim that IP rests entirely on them. So the sooner we can, come together under whatever guise or umbrella, the society will benefit largely from it. But it's still at its formative stage.
Thank you very much, sir. I would like to thank everybody. I especially thank my friends, my partners in IP Crusade, Barrister Nusa. You know, we have always been together. IP Radio is 1 year, and on Thursday there's going to be celebration, and that will be after our own program. So you have to change the time.
So it has been, the time is from 12:30. So don't worry, we'll join us.
Don't worry, we'll work on the time.
Yes.
So I also want to appreciate Mr. Tunji Aino. I really appreciate you. Thank you for your time.
Much.
And I want you also to be the arrowhead in your own area. You know what I mean? So that we can really have that full blown of the idea of IP. You know, where you have the lawyer, you have the valuer, you have the accountant, the economy is already made, because the law will come, the economy will talk, and then somebody have to account for what we have spent and what we are about to spend. So three of us, we are a good jolly fellow to really work in this journey. I really want you to be the arrowhead in that area. And I also want to thank my president for declaring this open, and also the second vice president. I appreciate you all and all the participants and members of our faculty. Thank you, Mr. Yomi Bishola. I didn't mention your name because you are in-house. We are together. I appreciate you. You know, we have always traveled together, move all around. all because of IP. And I'm sure that we are going to a destination. Thank you very much for your time. I appreciate you all. Thank you all. And I wish you a very pleasant afternoon. Thank you all. Mr. Nusa,
Thank
we'll
you.
talk later. And Mr. Inon, thank you very much.
No problem. Thank you so much.
Thanks for the
You're
privilege
welcome.
and the platform.
Thank you.
Thanks.
Thank you.
Thanks.
I also thank all our technical crew. Thank you, Mr. Umore. Thank you very much. Thank you. You know, I call you at odd hours, but you still perform. Thank you very much for all this. Wish you all the best.